welcome to Rightly Decided, the mostly originalist takes of the litigators of the Texas Public Policy Foundation. I'm Laura Beth Latimer, and I'm here today with attorneys Nathan Seltzer and Clayton Calvin, and our director of litigation, Chance Weldon. We are still playing catch-up on the last few cases that were released by the Supreme Court this session. So today we're going to talk about some election cases. Now, we talked at the beginning of this a little bit, like, on their face, both of these cases are about elections, but otherwise they really have very little in common. So we're going to talk today about Watson versus Republican National Committee, which we'll refer to as Watson, and the National Republican Senatorial Committee versus FEC. I cannot, to save my life, say NRSC correctly every time. So please be prepared for me to just say some slew. If it's 4 letters and it starts with an N, I'm probably talking about that committee.
Also, NRFC versus FEC, like just
NRSC.
NRSC.
I shouldn't be correcting you. I don't know.
I just said it wrong.
As someone who works in a policy think tank, just the
acronym
life. You just got to stop.
Man, I spent 5 years as a military wife. I had to count in my head how many years it was. 5 years as a military wife. And acronyms, you'd think that it would become like a second language at a certain point. No. You just start throwing it at the wall and hoping some letters stick.
Which is why we don't use acronyms in our briefs, to spare the judges.
But it's why we do use acronyms in our case filing system, so that we can't fill any of the cases apart.
To bring it back home.
Anyway.
We're going to be talking about Watson or the alphabet soup case.
We're going to start with Watson, and then we'll come to the alphabet soup case. So let's start with Watson. The fundamental question that this case asks is, what does it mean to elect? When does an election actually occur? So Watson starts and stems out of the Constitution, but this is actually a statutory interpretation case. So, Clayton, why don't you go ahead and give us the constitutional provision that leads to the statute that's interpreted in this case, so we can kind of walk through this step by step.
Yes, just in case we have any conservative listeners who are leery of the congressional use of authority over elections, because it is true the Constitution, for the most part, gives that power to the states. It does, but there is a part of the Constitution that comes right after that that says, so basically, the times, place, and manner of holding elections for senators and representatives shall be prescribed by each state legislature. But it says, and this is in the constitutional text, the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. So Congress does actually have some role in standardizing, and importantly, just times, places, and manners of the elections. That's it. But so this statute at issue here, the federal statute, its constitutionality was not challenged. It's just, how do we interpret the text? Sorry.
So what we have going on here is states are making regulations as to time, place, and manner as they're allowed to under the Constitution. Right. And the question is, can the federal law preempt, or does the federal law preempt with respect to certain regulations that the states have made?
Well, it does.
And in this case, preemption is actually explicitly in the clause you just read. So we know that
from 1787 too. This is an original part of the Constitution.
So the statute in this case is a Mississippi law that permitted collection of absentee and mail-in ballots after the day of the election. So the election is the first Tuesday, or the first Tuesday after the first Monday in November. And
every 4 years.
Every 4 years, I'll read that in a little bit. And then the Mississippi law permitted collection of these ballots if they were received, cast on or before Election Day, but received after Election Day. And the question was...
So they're allowed to do that under the Constitution, but Congress can preempt it. So
did Congress preempt, by passing the law, did they preempt the Mississippi law that permits collection of these later, after Election Day, received ballots?
So the statute in question, the Mississippi statute, says we can collect ballots up to 5 days after the election as long as they are postmarked by Election Day. So that is, you've checked the box on your ballot, folded it over, put it in the mailbox, and some postman somewhere has stamped it with Election Day on the ballot. If it is postmarked by Election Day, 5 days later, Mississippi says we can count those ballots. The question is, does the federal statute, which prescribes Election Day as being the first Tuesday after the first Monday every 4 years.
I have that exact language.
Please do. Please
Yes.
read the language of the statute.
So election day is defined as the Tuesday next after the first Monday in November in every fourth year succeeding every election of a president and vice president held in each state.
So does that language preempt Mississippi's attempt to say we can count ballots for 5 days afterwards? All of which is a very long way of saying, does the election occur when the ballot is postmarked, or does the election occur when the ballot is received, or does the election occur when the ballot is counted? Now, that's not really an issue that any of the parties bring up here.
Right.
Nobody's trying to say that the election occurs when it's counted, but I do think that that's a valid question in this statutory interpretation
it comes up in the
context.
reasoning. Yeah, right.
So obviously the Mississippi is arguing, no, the election occurs when the ballot is postmarked, and the federal government is arguing, no, it occurs when, or the Republican National Committee, rather, is arguing, no, it occurs when the ballot is received, when it gets into the government's hands. That's when the election occurs.
Because no one disputes that, sometimes counts take longer than 24 hours. There's, thousands upon thousands, millions of ballots in some states that are being cast. And it's always, for years, it sometimes takes more than 24 hours to tabulate all of those, particularly back when you were like hand counting all of these ballots. So it's not the counting.
In the horrible days of hanging chads.
Yeah. It's not the counting. It's whether or not the ballot has to be received by election day.
Yeah. What does the term election in this federal statute refer to specifically?
And the majority here, which consisted of Justice Amy Coney Barrett, who authored the opinion, Chief Justice John Roberts, and Justices Sotomayor, Kagan, and Jackson comprise the majority here. So we've got kind of this cross ideological plane where you have two justices who are typically considered conservatives siding with the three liberal justices in the outcome of this.
The two of the institutional conservatives.
Yeah.
Right. I mean,
ideological conservatives. Yeah. However you want to phrase
in
it.
In the 3-3-3 breakdown. Yeah.
Yeah. The five judge majority held that election occurs when the vote is cast. So the checking of the ballot, the putting of the ballot in the mail, and then ultimately verifying that date and time by the postmark. Yeah. That's when this actually occurs. So before we get into the substance of the statutory interpretation question, Chance, can you explain a little bit about preemption and what that would mean in this context?
Yeah, so preemption's pretty straightforward. The Constitution of the United States says that the Constitution and the laws adopted thereunder shall be the supreme law of the land, and that's notwithstanding any contrary state laws. And so when the federal government legislates, and that legislation is within the scope of its enumerated powers, not when it does something that's outside the scope of its enumerated powers, but if it's operating within the scope of its enumerated powers and a state law is contrary to that, then the state law is preempted. It fails. It's a sort of order of operations. It's overwhelmed by the federal law. You follow the federal law, not the state law when the two conflict. And that's basically preemption in a nutshell. And here you have a statute that's adopted under an express constitutional provision that allows, Congress to set the time, place, and manner of certain elections, notwithstanding state law.
And this is clearly, it's the time that we're talking about.
Yeah.
It's in there. It's not outside the scope
It's in the
power.
text. So basically anything that would be contrary to it, state laws contrary to it, would be preempted. And so really the only question here is what does election day mean under this federal statute?
So fundamentally, the majority decides that this isn't preempted, and they decide that it's not preempted because repeatedly in federal law, we treat the reception of votes as separate and apart from the casting of ballots. So even in the Constitution itself, when we're talking about, election day is when we cast all of these ballots, but ultimately several weeks and months later is when those votes are then sent to Washington to be counted in Washington. So the counting and receipt of the votes is actually separate and apart from the election.
I think the Fifth Circuit disagreed with that historically. I think this originally came up through the Fifth Circuit. The Fifth Circuit said election day means receipt by election day. And then counting is separate. No one disputes that you can count after election day. The question is whether you have to receive by election day.
But those electors aren't received by Washington until they go to Washington. So those votes aren't received by the government until they actually arrive there, if that makes sense.
Well, it's
And you
even more
don't say that
common
that's when the
constitution.
election happens. You
Right.
still say that it happens when the votes are
When
cast.
the votes were cast.
Yeah.
But that's the more common use of the term election day.
Election
When
day
we
would
all
be-
go when we get off work, Imagine if we all got off work for the day that the votes were ultimately counted. You know what I mean? That's not really how we talk about it. We talk about it like the day that the votes are cast.
Yeah.
And if you think about when they're writing in 1787, where you don't have, a bunch of states with mail-in ballots. I mean, election day was literally when you went down to, the local tavern or whatever, and you dropped your ballot in the little wooden box. That was election day. That's what it was. And so I don't think it's crazy, at least where the Fifth Circuit shook out, distinguishing between counting and casting, or counting and receipt. It's only in the modern era, or at least dating back to the 19th century, when you started to have like military have mail-in ballots and things like that you really start to see those things be separated.
Yeah, and because like you would ordinarily think that whenever I cast the ballot, that's when the government receives the ballot. Because there's not this transit time by U.S. mail between, like it's literally I'm putting it into the box and it's received there. So it's really a function of our developing society that we have to even make the distinction. And federal law does that. If you look at the statute that they reference, the Overseas Voting Act, it's the
Uniformed and Overseas Citizens Absentee Voting Act, which is the longest statutory name that has its own acronym, UVOCAVA.
UOCAVA. Yeah, at least that's easy to remember.
Yeah.
So another alphabet soup. Yeah. But we're still on Watson. Okay. But but that one that repeatedly refers to or presupposes that ballot receipt is a matter of state law, but not necessarily ballot casting. And so it says that absentee ballot shall not be valid if the state provides, it specifies a federal absentee ballot shall not be valid if the state provides an absentee ballot at least 60 days before the deadline for receipt of the state ballot under state law. So it's focusing on the receipt section, and so that's sort of it's assuming that ballot receipt is a matter of state law. Ballot casting is what the federal law is targeting at.
I think it's important that we start where Justice Barrett starts, because that's the second point that she raises. The first point that she raises is quite literally just the most textualist, most Scalia thing you can imagine. She starts with the word elect. Yep. What does it mean to elect? And to elect is to make a choice. And the question is it the electorate who's making a choice, or is it the individual who's making a choice? And at what point are they making that choice? They're not making the choice when it hits the hand of the person who's receiving it. They're making that choice when they're sitting there with their ballot, checking the box, and then handing that ballot to whoever is ultimately going to hand it to the federal election administrator.
But that alone wouldn't be enough, right? I mean, I don't want to jump ahead, but that alone would not be enough to satisfy the election day requirement, because otherwise you could cast your ballot, you could write in who you want on your ballot, seal it, wait to see how like the election's shaking out, and then deliver it the next day or 3 days later, and change the vote count. So it's not when you cast the ballot, right? So I agree that like whenever the individual writes their name or writes who they want in the ballot, that's when the ballot is in a certain sense cast. But we certainly wouldn't call that election day until you've given it to the government.
To transmit it to
I would say
else.
That casting the ballot to me would be it's out of my hand. Like I can't do anything
you
else
can't
about
change it.
it.
It's unchangeable.
You don't cast it just by thinking.
At what point is it actually cast where you've actually given it to?
Which is why the postmarked element is important in Mississippi's code, because fundamentally, once you have gotten to the point where it's been postmarked, it is in some postman's hand in some back office somewhere, and they've stamped it and they've said this has been received by the federal government. And that's not the argument that's being made here, but still, this is out of your hands now, and it is in someone else's hands. That vote has been cast. And an interesting point that came up at oral argument was, okay, can we recall those ballots? Like, is it possible for someone to walk in, like, hey, I've handed my ballot to the postman. He's postmarked it today, and then he turns to put it in whatever bushel or basket or rolly bin is going to ultimately go to take that to the post office. And I say, actually, you know what? I don't. Can I get that back, please? At that point, can he give it back to me?
Which you can in the mail ordinarily, right?
Ordinarily,
like you can recall
I think
letters.
You can. So if you decide to then recall your ballot at that point, you couldn't theoretically recast it. Like, let's say it's the next day or after election day, you couldn't then recast another vote, but you could call back the one that you actually cast. And that's going to change the outcome of the election. So in y'all's mind, do you think that that's a valid argument? Does it carry any weight or hold any water with you? Or is that just a policy question?
It's sort of a prudential question. I mean, I think it's not unreasonable, but you do have to sort of choose. It's like the mailbox rule from like anyone who's gone to law school.
Oh gosh, Civ Pro 1 in law school.
It's like you learn like, okay, when does this count as I guess assent for contracts, but is it when you put it into the mail or when the person gets it in the mail? And I mean, you can see arguments for both sides because you're making an agreement and there's a transmission in the process of an election. There's a transmission of your own conscience to the like body politic or whatever. So there are two parts to that, and there is a place of ambiguity in the middle, which is why this is a case. But I don't know. I sort of feel like I understand. I find Barrett's conclusion to be the more persuasive. You have to choose one.
Yeah, at some point we just have to go with one or the other. And I like the Fifth Circuit is not necessarily wrong. Well, I mean, I guess they are necessarily wrong, but like their idea wasn't from the beginning like ridiculous.
Well,
or something
four
like that.
justices agreed with them,
Right.
more or less. Yeah,
And it's not crazy to say election
3.5.
day is election day. But I also think too, it's not. I would push back a little bit that it's a prudential question. I think what you're actually doing when you create these sort of like reductio ad absurdum arguments, where that would mean you could call your ballot back, and then if that's the case, have you really turned it over to the government? Has it really been cast? Has it really been?
It's not a question of prudence; it's a question of definition.
Yeah, you're actually just trying to suss out how that definition works by pointing out places where it would seem to contradict the way that we ordinarily think of casting or receiving a ballot.
Yeah,
that's
a fair point.
If you can unreceive it, or like,
Right.
is it really
Is it cast?
Is it really cast?
Yeah.
Yeah.
Has the election actually been consummated, if you will, if you could still pull it back and undo what you've done?
Yeah.
So there's some problems with the majority's sort of framing here. Like you could pick at it, right? You can sort of undermine it, but are there more problems with the dissent's framing of it?
Yeah.
So I think that's
I think you're absolutely right. And ultimately, obviously, the majority prevailed here, but the dissent's position is that election day requires the receipt. That's ultimately, this entire division comes down to that simple question of, does election require receipt? And the majority says yes, and the dissent says no. And I think there are more absurdities that occur if you say, yes, it does require receipt.
Well, can I ask a question of the group? Because we haven't talked about this beforehand, so I'd be interested to hear what you guys say. But it does seem to me that seems to be the prudential reasoning going on in this case, is basically if you say election day is receipt by election day, like that election day means day, which I think is the more ordinary understanding of that term, the downstream consequences for mail-in voting are
they're
big.
immense.
And so we have to talk about like which side is doing sort of a prudential kind of policy-based reasoning. I think it's probably the majority. The majority is making the argument that we'd have to unwind a ton to adopt this view of the text.
And imagine all the people, if you sent in your mail-in ballot like a few weeks beforehand, maybe it gets lost or something, and then your vote doesn't count anymore, you're going to be real mad at your government.
Or more specifically, I was explaining earlier today, I have a friend who's a service member and happened to be in training in October and November. And so he just out of pure caution, he's a very politically active person. So out of caution, he decided to take a picture of himself with his ballot. So if his ballot got lost, he could be like, hey, no, I actually did vote in this election. Yeah. I know it says, if you look up GOP Data Center or whatever, it says I didn't vote, but I did, I swear. He took a picture of himself with his ballot and then mailed it in. And his ballot was received about 2 months after Election Day, even though it was going from a federal office where he was training to the federal post office to the federal government. It was lost in that process. And it is obviously his vote wasn't counted because by 2 months after, his candidate had already conceded, actually. So like it didn't end up mattering for him. But it is frustrating to think that could be the case, even if you were dealing with like I put it in 3 days beforehand and the mail took 4 days to get there. We know that that's how the post office works sometimes. So I can see that prudential reasoning on behalf of the majority here.
I mean, just the reason that I asked the question is we talk a lot about like YOLO originalism and YOLO textualism, which we tend to favor this sort of idea of, again, for people who are older in the audience, like YOLO, you only live once, right? This idea that I'm going to follow the text wherever it goes
Say what the law is, and the chips will
let
fall
the chips
where they
fall
may.
where they
Let the
may.
chips fall where
It's,
they may. Yeah.
Justice Gorsuch reading the treaty to give Oklahoma back to the Indians in McGirt. It's like, that sounds like a Congress problem. That's what the law says. I'm going to play it out. And if that's what the text is, my job as a judge is to say what the text means and give it its most ordinary meaning.
Mm-hmm.
And so many of these issues that we have with mail-in ballots, even with absentee ballots for the military, like, those are real problems, right? But when we're talking about the way we thought about election day in the Constitution, or the way that we thought about election day when the statute was adopted, I mean, are those really things we should even be looking at? I mean, maybe it really just is day means day, and that means that we either have to have Congress rewrite the statute, or we have to change the way that states do mail-in balloting.
This is a Congress problem. Again, this is just the courts having to grapple with something that they shouldn't have to grapple with because Congress hasn't done their job in a while.
Yeah.
And with the evolution of our technology and with the evolution of our world and the rate at which it is shrinking, it is necessary to revisit this language and just clarify. That language that Nathan read is confusing and convoluted and dated.
Yeah.
And that's a problem. Congress could very easily, with the votes that we have, change that language to reflect the needs that we need met.
This isn't the
and the
first time
policy
this issue's come up.
preferences of the majority. But
I was just pushing back a little bit on it's pure textualism the majority's doing.
No.
So I'm not sure that it is.
I agree, but I think that to an extent both sides are trying to do textualism, but at the end of the day, it's going to kind of be a policy issue because it could go both ways.
I might push back just a little bit. Like, it's not that prudence is taking precedence over, just textual interpretation. I think it's a fair reading to say that election, the word that they're actually parsing out is election, and that's taking place on this day. But the verb election is taking place when the ballot is given over.
Isn't the term though election day?
Yeah, I guess that's an interesting. Are we talking about election or election day? And when you put it as a day, does that take on its own textual meaning and its term of art?
Tends to be singular. Otherwise, you would add an S.
It
would be day.
No. But the day that the day that the election takes place is the day that the verb of electing takes place, which is when you're casting it.
But the
and
question
I think that's
is
a perfectly textual. I don't think you have to resort beyond the text and just to prudence to say that.
No, I was just pointing out when we talk about like the downstream consequences of it. In a lot of ways, you are going beyond the text. And look, that's not always crazy. I mean,
when you're thinking of that. Yeah.
I mean, Judge Ho has pointed out before in other podcasts when he's been talking about the way that he thinks some sort of pragmatic.
Judge Ho of the Fifth Circuit.
Judge Ho of the Fifth Circuit has mentioned that. He doesn't let the pragmatic things override the best reading of the text, but if there's something really absurd that comes out of his reading, he may pump the brake and think about it again, because you assume that the Constitution is going to be reasonable. You assume a certain level of rationality in the way that the text of statutes and the Constitution work, and so you want to, if it's actually creating something that seems really pragmatically crazy, you want to at least
give it a pause.
Give you pause, give it a second read, and then ultimately be very deliberate about whether or not you want to blow that up. And I think that's fine.
Mm-hmm.
But it's when you allow the pragmatism to actually influence
the
meaning of the text that I think you're doing it wrong.
When you're not using it as just one canon of interpretation that guides you to an accurate meaning or not.
So the majority is saying when the ballot is cast, that is election day. The dissent, which is 4 justices, very close, is saying that when the ballot is received, or collected, when the government has collected them, that is election day, and that's got to be complete on election day. And so we just have like one justice difference in that difference of both sides clearly have textual support, I think.
Mm-hmm.
Yeah, I think this was a close case in more ways than one, especially because Justice Kavanaugh wrote his own partial dissent. So like he's kind of splitting the baby. You could say this is 4.51 to 4 point whatever. It's very, very close how this came down, and it makes sense. I think you can tell just from this conversation at the table that this is a close question, but it's one that could easily be solved by Congress like that. So let's turn to NRSC. Oh, nope, we've got a scoreboard first. Sorry, Nathan, go ahead.
So in Watson, the court decided 5-4, very narrow, that states may count ballots received after Election Day so long as they're postmarked by Election Day, and that doesn't violate federal Election Day statutes.
So
easy.
Close one,
which
but
are constitutional.
but easy. Okay.
Yes.
So let's move to National Republican Senatorial Committee versus the Federal Election Commission. So the issue in this case is actually a First Amendment issue. And the question is, are party participation limits, so the name of this act is FECA because we needed more. It's the Federal Election Campaign Act. Prohibits political party coordinated expenditures beyond a certain limit.
Campaign
and the question is, right, do those limits of political party coordinated expenditures violate the First Amendment? That was the issue that was in front of the court.
So to put some meat on the bones, that's when, say, the Republican Party has money that's been donated to the Republican Party and coordinates with a campaign for doing specific campaign advertising for a specific person who's running for election.
Yeah. So, for example, if I was running for office and somebody donated to the Republican Party and said, hey, I want you to run TV ads for Laura Beth Latimer, and the Republican Party comes to my campaign and says, yes, we're going to run campaign ads for Laura Beth Latimer. And my campaign says, great, let us help you put together. That's coordination, and it's campaign coordination with the political party.
Yeah.
If you don't run in the same incredibly political circles that those of us who work in TPPF do, that might be kind of a foreign concept, but that is actually limited. There is a limit to the extent that political parties, or at least there was before this, could coordinate with campaigns to create campaign materials and to finance other campaigns.
And disclaimer, none of us are election law attorneys.
Absolutely
not.
not.
It's quite technical.
That is a labyrinth that we do not dip
It
into.
absolutely is. And so our view on this is going to be very 10,000 foot because the nitty gritty of it, frankly, to me at least, is not particularly interesting. I don't know about you guys, but there's a reason I didn't go into campaign finance law. But the overarching thing that I don't know that a lot of people understand is exactly the extent to which campaign finance is tailored and hemmed in on every single side. Yeah. Like, there is not a single dollar that goes through a campaign that is not regulated by the federal government in some capacity. And the question is, at what point do we cross from reasonable limitations to prevent quid pro quo, which is an evil we'll talk about in a minute, and when have we exceeded that and just started infringing on people's First Amendment rights?
Yeah.
And these this law here these limitations apply irrespective of whether the donor is trying to coordinate with the candidate. Is that right? Does that make sense?
Yes.
Because in your example, you were saying the donor gives to the party and the party coordinates with the candidate.
Yes.
But actually, what the donor wants is actually not relevant to the limitations. Correct. It's just like a party and the candidates, which are part of the party, are coordinating with each other because that's what happens in a campaign, and the money's going back and forth. But that's what this law.
As we'll get to, though, the concern with
that's the concern.
Yeah,
right?
the underlying concern is that the donor will give all this money to a bunch of different places, then they'll all coordinate, and therefore the donor is able to circumvent the restrictions on how much money he's allowed to give.
Yeah.
But we'll get into that in a minute.
Yeah. Let's start with the law, I guess.
Yeah. Let's start with the law itself. So, FECA. Oh, I hate that. Restricts political parties from spending money on campaign activities in coordination with their candidates beyond specified monetary caps. I'm not going to read the entire statute because it is very, very long, but that is the gist, and that is the core of this case. Is we have these specified monetary caps, and our Republican Party, our Democratic Party want to spend money on these campaigns in excess of that. Is it their First Amendment right to do so? So the first kind of background principle that's running around here is campaign speech, is donating to a campaign protected by the First Amendment at all?
Yeah. And I think for folks that aren't lawyers, perhaps, certainly folks of certain political persuasions would argue that, money isn't speech, right? But I think if you think about it for more than just a couple of seconds, you realize that's not true. So if I want to even go picket in front of, a business or something, I've never picketed for anything. But like if someone hypothetically wanted to waste their time by picketing.
You're the guy with the cardboard sign talking about surfboards.
What is it like? I'm against picketing, but I don't know how to show it.
No picketing, no more picketing.
Yeah. But so if I wanted to picket, I'm going to have to spend money on markers and poster board, and that too is part of my speech.
If the government constrained that and you weren't able to do that, that would be a problem.
It would be a restriction on speech.
So, for example, if Congress was to pass a statute that says picketing is totally okay, picket all you want to, yo, but you're not allowed to buy materials with which to picket. Now we have a First Amendment problem.
That would implicate the First Amendment. Same thing. Like if I want to put out a newspaper ad, for example, like in the Austin American Statesman about some political issue that's really important to me, and I want to buy space, I have to pay for that. And if the government passed a statute or a regulation that says when you buy that, you can't, you can run whatever ads you want, but you can't spend money on it. Well, that would effectively be a restriction on the freedom of speech. So this idea, I know that a lot of folks, particularly on the left, are like, money isn't speech, corporations aren't people, yada, yada, yada. If you think about it for more than half a second, you realize that's just not true. Like if the federal government were allowed to just prohibit you spending money on political speech, it's backdoor prohibiting you from engaging in the political marketplace of ideas in any meaningful kind of way.
Not to mention that you need money in order to take time off work to go demonstrate and things like this. And so the money enables you to do those things. And you can use money to place an ad or something like that. But I can't just personally, I wish I could just take out some time off and go to Washington, D.C. and go talk to my congressman.
Full-time protester.
Sure. But I can't do that.
And it's impossible to run elections without money, right? In elections, even if you're thinking about the core of the First Amendment being political speech to basically be able to petition the government for a redress of grievances or be able to decide who's going to represent you, even the most democratic form of speech, when you think about it, is having people run in these elections. And like Ocasio-Cortez, for example, who's like a bartender or whatever in New York,
that's a good example.
There's no way for her to run a campaign unless somebody is paying for it.
Yeah.
Right.
She didn't just have the money in her back pocket to
even to just stop working.
Famous.
Yeah.
Even to just take the 3 months or whatever off of work that's necessary to go run a campaign.
I mean, you have to file for ballot access. Ballot access costs money. You have to be able to go to events. You have to hold town halls. And all of that costs money. And the way that people support candidates in order to function in our democracy is to actually give those candidates money. And so that is why, just on the front end, I know we weren't planning to talk about this, but that is why we talk about campaign expenditures being protected by the First Amendment.
Yeah.
Because the federal government can regulate who you can give to and how you give to them and how much you spend. At some level, that implicates the First Amendment, because that means that's one less newspaper ad that I can run. That's one less poster board that I can use when I picket. That's, one less town hall event that the candidate can have. And all of those things, if you think about it for 2 seconds, people, are restrictions on speech.
Yeah.
Yeah, and here's
rant over.
Here's a nerdy CAF thought. Also, I think about the Lockean and Madison idea that your conscience is a part of your property. So both your money, your speech, and your conscience are all already just part of your property, your person, and these are all part of the bundle of things that need to be protected at all costs by people. So
which is why we have a First Amendment in the first place. So the competing policy issue that's underpinning this, if we're just going to steelman this argument, the competing policy issue is the concern about quid pro quo. So the concern that I am a very, very wealthy donor and I am going to give money to Chance, and Chance, when he is elected to office, is going to do all of the things that I tell him to do because I am his very wealthy donor.
Well, at least one thing. At least one thing. But the idea is I can use my money to buy off a candidate so that candidate will do what I want them to do.
Special interest.
That is right. That is the concern that underpins these campaign restrictions.
Right. And bribery, which is validly illegal.
So the basic protection for that is, like you said, bribery statutes. We have statutes that directly prohibit quid pro quo. That is absolutely illegal. You cannot do that.
Right.
However,
that's not what's at issue here, by the way.
That's not what's at issue here.
Those are completely, no one argues that violates the First Amendment. That is a protection against fraud. That you basically can't buy votes that way.
It is speech that has never been protected is bribery. In fact, if you look in the book of Proverbs, as far back as you can go, bribery has been
no one's arguing,
unprotected.
No one's arguing that you can't prohibit bribery. The question is,
Can you pad
put
it?
a prophylactic?
Yeah, exactly.
Right. Can you pad the room that it lives in to make sure that nobody even attempts or does anything that might look like it? And this is even a step beyond that, because this isn't just general campaign limits that we're talking about. This is campaign contributions from a political party. So like Nathan said, that step in between, like Clayton said, that step in between, I as a donor don't even have to say, hey, I want you to give my dollars to this candidate. I can just be a donor, give my money to the Republican Party. The Republican Party can then turn around and give money to the campaign. But we're putting a limit on that to prevent me as an individual from telling the party to tell the candidate to do what I want him to do if he wants my money. And that's crazy. That is so many layers of prophylactic.
Yeah.
Also, it surrounds it's like core political speech too. I mean, this is like the point of the First Amendment. Like if you were to take a super narrow reading of the First Amendment, you would say that only political speech is protected, and that's what is at issue here. This is like political parties. This is like the way that representative democracy works. And
it brings us to a really weird point, which is that the standard for this is not strict scrutiny. It's something else.
Well, it was.
We'll call it closely drawn review. I don't know.
Did we already unpack the fact that we talked about the statute, and then we said that there's a challenge to the statute, and now we're nerding out about the way that the challenge plays out? I'm not sure. I can't remember what we were talking about 5 minutes ago.
Sure. Yes. So ultimately, the decision, we haven't talked about the decision of the court yet, if that's what you're asking.
There's so many interesting things to talk about.
There's too many interesting things
to
talk about.
Well, I ranted for like 5 minutes about how money is speech, so.
So what the court came down and said is that campaign limits, party coordination limits on political parties specifically are a violation of the First Amendment and are therefore invalid. That's what the majority of the court, the 6 what we tend to think of as conservative justices, held this, and the 3 liberal justices dissented.
And I want to say, like, the same question as applied to like corporations and stuff is left for another day. I believe.
Yes.
This is just for political
parties. This is very specifically political parties.
On that ideological split line, this is one of those really very few cases where we have what everyone assumes is like the ideological split that always happens.
Mm-hmm. Yeah.
This is the most fractious, like the most ideological splits that has happened in recent memory. And there was only 23% of the cases this term were decided 6-3 with
along ideological
lines. The ideological lines.
Yeah.
80% is some mix of the other, and a bunch of them are unanimous.
Yeah, almost half are unanimous.
Yeah.
And so I think that we had this idea that they're like the 6 justices are always in lockstep with each other, but as we just went with the previous case, it was 5-4 with 2 of the court's conservatives joining with the 3 liberals to go the other direction on the case. So that doesn't always happen. The fact that the breakdown is so rare, and that the most common breakdown is actually the unanimous, but the breakdown where it's 6-3, that's so rare, I think really just shows that the narrative that we get in the media about, the conservative court did this or the liberals did this, is really just a false narrative. It's really just smoke. And that the reality is that a lot of these cases, the majority are decided on or not, almost the majority is unanimous. I was actually looking, we'll go into statistics in another episode, but some of the statistics on justices agreeing with each other are really interesting. There's almost there's only one alignment of justices where they don't agree the majority of the time. Between all 9 justices.
They usually, every combination agrees most of the time except for 2.
Yep.
Interesting.
Do you know who the?
Very interesting.
I could probably guess off the top of my head.
You'd be right.
So let's come back to why the court came out the way that it did. Instead of, I know we've hammered this drum probably too many times, but instead of just asking, does this violate the First Amendment? Yes. Checkbox, invalid. The question that the court asks is this closely drawn? So is it proportional to the asserted government goal, and is it necessary and narrowly tailored? So it looks a lot like strict scrutiny. We're not calling it strict scrutiny because we need too many levels of scrutiny. And again, this is a drum that we hammer a lot. Like, why are we trying to use these tiers of scrutiny instead of just asking the question? But it's whatever. Setting that aside, that's the question that the court sought to answer. Can
we beat that drum for just a second?
Okay, please beat that drum.
Okay, I'm going to beat the drum again for just a second. So what you would ordinarily do if there hadn't been 100 years of weird jurisprudence, is you would say, what does the text of the Constitution say? And it says, Congress shall make no law abridging the freedom of speech or the press or religion and things like that. And so the question here would be, are these sort of campaign expenditures, are they speech as ordinarily understood? And you would look at dictionaries and you would look at contemporaneous.
As understood in
17,
at the passing of the First Amendment or the incorporation in the Fourth Amendment.
Yeah, at the time, because this is Congress, it would be at the time of ratification. What did speech mean in the late 18th century? And that'd be pretty straightforward. You would look at dictionaries, you would look at contemporaneous writings. Depending on how much you believe in the text, history, and tradition approach, you could look at a little bit of post-ratification stuff, but not a ton. And you would try and just understand what the words on that page meant, just like you would a contract. And
just like you would the Second Amendment, maybe?
Yeah. And you would apply that to the First Amendment as well. And you would say, like, look, these things certainly, as we talked about earlier, implicate speech. And therefore, because of that, they are likely unconstitutional unless they fall into one of these exemptions for policing fraud or abuse or something like that. That would take them outside the scope of protected speech. That would be the entire analysis. But because of, the way the law developed in the 20th century, you have the court trying to create balancing tests that feel a lot more like policy for each one of these rights. So what they start asking is, how important is the right and how important is the interest that the government is trying to achieve? And then the court's role under these balancing tests is to balance the competition between the right and the government interest, which is
defeats the point of the fact that a right is by definition a jurisdictional bar on government. It's not.
And it's clearly just a policy-based restriction. It's something that the courts in England used to do all the time, because you didn't have a true written constitution in England before we became America. And one of the fundamental differences is all of the rights in the British Bill of Rights were all just principles of good governance. And so it was all like, unless Parliament deemed it in the public interest. And so you would always have to do this balancing test for all of the rights. And now in the 20th century, we've done the very thing that we tried to move away from whenever we actually created a written constitution. So over the years, you get these tests and then test on top of test and angels dancing on the top of head of a pin, where 90% of the fight in the case is simply, is it strict scrutiny? Is it sort of strict scrutiny? Is it intermediate scrutiny? Is it rational?
Is it closely drawn review?
This one here is closely drawn, meaning it may not be disproportionate and must be necessary and narrowly tailored. Word salad of the other tiers, basically.
And
what does that mean?
Those are all policy justification. They're like saying, is the policy strong enough to justify the law, rather than just look at the text of the First Amendment, which begins with the words, Congress shall make no law. We could make this a lot easier. And that line appears a nod to text history tradition appears in this opinion. He says, Justice Kavanaugh in the majority says, as a matter of text and history, therefore, the restriction on political party coordinated expenditures would appear to violate the First Amendment. So we're like halfway home.
Yeah.
We just need that.
And then
get rid of the scrutiny stuff.
And then he proceeds to do the scrutiny analysis.
And then he does the scrutiny analysis.
At least he noticed.
But in this case, at least the scrutiny analysis aligned with what we would consider a traditional First Amendment analysis and landed on, this is not narrowly tailored. There are other ways that we could reach this same end at CEG, all of the other laws that we have. For example, earmarking is already limited and treated as an individual campaign contribution limit.
Yeah, there are less restrictive means here.
There are less restrictive means, so therefore this violates the First Amendment. Which brings us to Nathan. You want to give us the scoreboard on this one?
Absolutely.
Do we want to talk about the dissents? Because we just kind of dumped all over this law. But clearly are we? No.
Sorry, we're butting up against a hard timeline today.
Producer's like, absolutely not. So, So 6-3 on ideological lines, the court decided that it's unconstitutional for Congress to limit campaign expenditures in coordination with the political party.
Bam. That's it. That's the decision on this one. And I don't know that we have time to say anything else. So I'm going to wrap us up. If you have enjoyed our conversation today, please join us next time for more Rightly Decided and leave us a review if you feel so called. Thanks.